Welcome back to True Crime PhD, where we break down the biggest cases and uncover the legal strategies that shape them. Today we're diving into an important update on YNW Bortlen, also known as Cortland Henry, and his recent plea deal. We'll also explain what a proffer is, why it matters in criminal law, and how it played a role in Bortlen's agreement with prosecutors. In criminal law, a proffer is often referred to as a queen for a day agreement. It's essentially when a defendant sits down with prosecutors, usually with their attorney present, and gives a full statement about what they know. The purpose is to share information in hopes of reducing charges or securing a lighter sentence. Typically, the defendant provides information in what's called a proffer statement. Prosecutors agree, usually in writing, that the statement won't be used directly against the defendant in trial. This is called use immunity. But there are limits. If the defendant lies, leaves out important facts, or later contradicts themselves, that protection is void. The proffer can also be used to impeach them if they testify differently at trial. But not always, as we see here in the YNW Bortlen case. So in short, a proffer can be a calculated risk because it can help a defendant, but it also gives prosecutors more insight into the case. YNW Bortlen's proffer and plea deal. Now let's connect this to Bortlen. He was originally facing 2 counts of first-degree murder for the deaths of Anthony YNW Sackchaser Williams and Christopher YNW Juvie Thomas Jr., charges that could have meant life in prison. But earlier this month, Bortlen reached a deal. He pleaded no contest to lesser charges, specifically being an accessory after the fact to the murders and witness tampering. The result? His first-degree murder charges were dropped. The sentence is 10 years in prison with credit for time already served, followed by 6 years of probation. Proffer agreement. As part of his plea, Bortlen signed a proffer. That means he has already given, or will give, a sworn statement about what he knows regarding the case. He can also be required to testify if called, and in that situation, he cannot refuse to answer by pleading the fifth, at least not on matters covered by the proffer. His attorney has made a statement stating that he will not snitch or provide any information that would point to Melly being guilty in trial. He don't have to provide any information, and not for Melly or anyone else or any other case. So, this is a miracle deal, simple because neither he state or defense wanted to go to trial in September, but the judge denied their motions and was forcing it. So, YNW Bortlen will not be required to testify against YNW Melly. Importantly, the deal does not obligate him to testify against YNW Melly in the upcoming retrial. Prosecutors have the option to call him, but he isn't bound to take the stand unless they decide to use his proffer in that way. This is a major development because it shows how prosecutors may be reshaping their strategy in the YNW case. By securing a sworn proffer from Bortlen, they gain insight and potential leverage for Melly's retrial. Without taking the risk of 2 murder trials at once. For Bortlen, the proffer and plea deal mean avoiding a possible life sentence and trading it for a decade in prison plus probation. It's a dramatic example of how cooperation and negotiation can change the entire course of a case. So, to sum it up, a proffer is a strategic legal tool that can protect a defendant while still giving prosecutors valuable information. And in Bortlen's case, it was the key to dropping the most serious charges he faced. What do you think? Did Bortlen make the smart move? Or did this deal raise more questions than it answered about the murders of Sackchaser and Juvie? Let me know in the comments below. This has been True Crime PhD. Make sure you subscribe for more in-depth breakdowns of the cases everyone is talking about and the legal strategies most people miss.